Very well. We continue with the bulletin tonight, but it is that part where we get to have conversations on matters to do with the law that was passed in the country. Now, Katto Wambua is an advocate and will be breaking down for us the Computer Misuse and Cybercrime Act of 2024. Katto, welcome to the program. We continue to have this conversation. I mean, it is one that has continued to stir mixed reactions in the country. There are those who are saying it is important that we have this law. There are those who are saying, apana, this law needs to go away. But as Kenyans just ask the question, what's so wrong? What is so bad with this law? What is the hidden part of this law that perhaps just reading it, one would not understand?
Thank you so much, Dennis, for having me. Allow me first to pay my homage and condolences to the family of the Right Honorable Prime Minister. He was a great statesman who fought for some of these freedoms that we are going to be discussing. I think it is very important that to honor his legacy, that we continue in really upholding these freedoms. Now, the main problem with these amendments, maybe I can just give a brief background. The Computer Misuse and Cybercrimes Act was designed to respond to the fact that the Kenya Information Communication Act did not have a comprehensive cybercrime regime. And the law was passed really to protect Kenyans from cybercriminals. However, recently, the amendments have been done to this act, and they were sponsored by the MP for Wajir East, Aden Mohammed. There are four principal amendments that they have done to this act. The first one is to introduce the power of the National Computer and Cybercrimes Coordination Committee to be able to direct the removal of not just content, but even shutting down of mobile applications and websites. That is really the main problem with these amendments. The other amendments were really fairly routine, relating to expanding the scope of phishing, which is how people do cyber fraud, but also an amendment to expand what cyber harassment means to include situations where, for example, you're likely to make someone to commit suicide, which is quite controversial. And then lastly is to criminalize what we call SIM swapping, where you take a SIM card of somebody else and alter it or use it without the lawful authority. Yeah.
Yep. So, you know, when you talk about this law, let's read it together with other jurisdictions that have had similar laws, right?
Yes.
So we want to talk about the European Union, who have the DSA Act, and DSA Act has come to even go granular to explain at what point then can the DSA Act shut down, say, your website. But this law is so vague because today, let me give you an example. I have a website. I have said politician X, Y, Z is not fit for office because of A, B, C, D. Does that warrant, can this law then move in and just shut me down? As well, there are arguments out there that this law pretty much would give the C4 committee, NC4 committee powers to shut down the internet like what we are experiencing in Tanzania. Are those fears real because of this act?
Dennis, those fears are actually absolutely real. And young Kenyans, since the Gen Z protests began, have already been facing the brunt of the state trying to clamp down on political dissent and opposition in the cyberspace by criminalizing speech Now, it is very important. I think you're alluding to a very important point, that we can actually have very pragmatic, targeted solutions to addressing, harmful content. But first of all, we have to define it very specifically. If you look at the European DSA, the Digital Services Act, which is a sister legislation because the current law we are talking about is based on the Budapest Cybercrime Convention.
Yes.
The Europeans have a way of ensuring that you can enjoy your rights to freedom of speech and expression, but at the same time, you're able to actually, where you go overboard, they have a very prescriptive definition that is not vague of what is harmful content, what is intentional harassment, and such things, so that we are avoiding a scenario where we are almost using a big hammer to kill a mosquito. And that's really the problem. And especially in the run-up to the next general election, Kenyans are right to be very worried that this law is going to be used to clamp down on political expressions that the government is not happy with.
So I hear you say in simple words that this law is meant to clamp down on dissent.
Yes.
But I want us to look at that part and look at the freedom of expressions, freedom of the media, the freedom of speech in the country as enshrined in the Constitution. And one would say any other law that comes to contradict the supreme law is rendered null and void. I know many have gone to the court to challenge this specific law and its implementation. We know a presidential candidate, that is Reuben Kigame, has gone to court to challenge this. So how does this then read with the Constitution? Is it going to strip Kenyans the ability to speak to power? And is this as well meant to clamp down on political dissent, especially now that you are headed towards 2027?
You're very correct, Dennis, to say all of this, because what we are seeing is that the power being granted to the NC4, which is actually not supposed to be an enforcement platform.
What is NC4?
The NC4 essentially is a committee for coordination, interagency coordination of government action to address cybercrime and cybersecurity. It has representation from the PS of Interior, the
NIS.
Attorney General, the NIS Director, the Director of Public Prosecutions, the Director of Communication Authority, and such representation. Essentially, it is an executive coordination, collaboration platform. It is not supposed to become the final arbiter on Kenyans' right to express themselves, especially the manner in which this amendment has been done. It has zero judicial oversight to it. When you compare it, for example, with the European one that we were just discussing, you're able to actually have a fair administrative approach to removal of harmful content, that you have clearly defined what it actually is, not like the way we have currently, but also with real judicial oversight. This was basically not just violating the rights or potentially going to violate the rights to expression, but it violates the constitutional architecture of the country. We have separation of powers, and it is very sad that Parliament literally ignored the views of Kenyans during public participation. If you read the report of the parliamentary committee, chaired by the Honorable Member for Dagoretti, John Kiari, the very Ministry of ICT told them that this power would violate the Constitution.
Wait, saying the government through the ministry,
Yes.
told the committee
Yes.
that the powers that have been given to NC4 would violate the Constitution.
In regard to this particular amendment, where they are trying to introduce the power of NC4 to be able to direct which websites will be closed, which websites will be, which mobile apps, including your, for example, your YouTube account, your X platform, your various social media accounts. They did not just ignore what the ministry told them. They ignored cybersecurity professionals in this country. There is what is called the Kenya ICT Action Network. They told them very clearly. They gave them even very sound alternatives, which I am suggesting, that we can adopt, for example, a very partnership-driven framework where government works with tech firms to remove content that is very targeted, not closing the entire, for example, YouTube or X platform as it is happening in our neighboring countries. You can use, today we have AI, for example, content filtering.
Filtering, yeah.
Okay? They can be using all these tools, but it needs to be done with proper judicial oversight. You cannot have the executive taking functions that are quasi-judicial in nature.
When you talk about proper judicial oversight in making all these decisions, what exactly does that mean? And how would this judicial oversight then come to confirm to Kenyans that their rights are still protected despite the implementation of the Act? The absence of this judicial oversight, what does that mean to a young person using the internet, speaking straight to power? Absence of the judicial oversight, what does that mean?
It means what you've been seeing, where young Kenyans are being charged with cyber harassment for speaking truth to power. They're being charged with even terrorism for speaking truth to power. The reason why we are insisting on judicial oversight is very simple. When you read the Act in Section 3D, it clarifies what are the objectives of this Act. Every law, when it is passed, must specify what is it for. And on the one hand, it is saying that it is there to protect Kenyans from cyber criminals or cyber crimes. But at the same time, it is saying that it is there to protect the rights of Kenyans to freedom of expression, freedom of the media. It is in black and white. So the whole reason why we are insisting on judicial oversight is to have that balanced approach where you can address cybercrime while safeguarding fundamental freedoms. And this is being practiced elsewhere. We are not supposed to be reinventing the wheel on some of these things, because when it comes to the cyberspace, we are not an island. Cybercrimes, in fact, are transnational in nature. So we should be taking that pragmatic oversight, judicial oversight-driven approach where we can be able to address, for example, crimes of cyberbullying. We are not saying people should be bullied, but we are also saying that politicians, especially public officials, should not be hiding behind cybercrime harassment to clamp down on criticism that is very fair. Secondly, we are having, this is a problem that has arisen primarily because our parliament has abdicated its functions. When you look at the current ruling coalition with its supermajority in the broad-based government, they are literally passing basically laws when they don't listen to what Kenyans are saying. It is not that Kenyans did not participate in the formulation of this law. They gave their views, just as they did during the finance bills, and they were ignored. So you wonder, when you listen to some of these MPs defending these amendments, who do they really serve? Do they serve the people, or are they just another extension of the executive? Do they understand their role, that they are supposed to be there to do checks and balances between themselves and the executive?
You know, Katto, when we just talk about the amendment that was done, when you go back to the original law,
Yes.
it will be remembered that that is actually part of legislation that originated from the DPP's office. And
Yes.
this was targeted to what it wanted to achieve. Fine, there is need to have amendments, but the way this has been approached, with all the advice that the committee was given, with all the input that was given by professionals, those that one would say know more about cybersecurity space than the members of parliament themselves, because this is a space they deal with on a daily basis, all this advice was ignored, and seems as though this amendment from the word go was meant to achieve a specific function, which is to clamp down on dissent. Now, as we go to the elections, as the campaigns continue, and this law is being implemented,
Yeah.
paint a scenario of what we will keep seeing on a daily basis.
First of all, we must thank all Kenyans who have, like the Right Honorable Raila Odinga, who have fought for this constitution. It is the reason why, as we speak, these sections have been suspended by the courts until they hear these cases fully. But we have seen other countries in the region where, for example, today we have been having an election in Tanzania, a general election. YouTube has been closed. X platform has been closed for months. The president is posting about when she was voting to an audience that has no access to the internet and are not on the X platform. Yeah, exactly. Unless you have VPN. So we are going to be forced as Kenyans to start using VPNs just to express ourselves. And that is why all Kenyans, and this includes even those who are supporting government, they need to understand that today, for example, I'm the co-secretary general of the UGM party, and with our presidential candidate being the retired Chief Justice Maraga. If Kenyans elect him to be president, I would hope that the people who are passing these laws and defending them would be happy, would not be complaining the same way we are complaining currently. We should not be passing laws purely just for partisan reasons or for temporal reasons of winning elections and silencing critics. James Orengo once told us, you know, government, it's own. So we should be very careful when we are passing these laws. And that's why I would want to probably not just complain, but give proper, you know, way forward.
Yes.
The first thing is, even as we await for the courts to answer or give their pronouncement about the constitutionality of these amendments and the wider law, because the petitions that have been filed, which UGM is in support of, one is challenging this power of the NC4, but others are challenging the original act and its application in Section 27 when it comes to cyber harassment. Now, the solutions, even as we wait for the courts to pronounce themselves, are, number one, we need to amend the law. Nothing stops Parliament, National Assembly going back, read that report that they published. In fact, it is very curious that one of the observations of the committee itself, because when you read the report, you have the consolidation of all the views Kenyans gave, and then the committee gives its own observations as to those comments. And one of their comments is actually that, in fact, they should not be amending the law. But they should be looking at other ways of addressing cyberbullying and such things. So the first thing we should do is return back this NC4 back to being what it was originally meant to be, which is a coordination, collaborative framework of state organs. Number two, strengthen, if necessary, under Section 46, currently strengthen the power of the courts to actually give this judicial oversight that I'm talking about. Currently, under Section 27, for example, you can actually go right now to court and seek for the court to give interim orders where you feel you're actually being bullied. Yes. But the lacking power for the courts is now this issue of removal of content, and they gave it to the NC4. That's the issue. So we need to strengthen the court's function in line with Article 159 of the Constitution, but also we need to ensure that we don't just pass laws to Kenyans, especially without serious, not just public participation, but public awareness. We need to train and speak very openly about these things, and I think a show like yours, dedicating time to this, is very important. But lastly, also we need to introduce proper definitions on what entails some of these elements of these offenses. What is intentional harassment, for example? What is harmful content? We need to have a very prescriptive list so that we are not, fishing for everything and carrying our freedoms away when we should actually be protecting
the very same rights.
Yes.
Yep. Katto Wambua is an advocate and the co-secretary general of United Green Movement Party, UGM, and we continue to have this conversation on what really does this law mean. We continue to have this conversation. It is important. Some rights that have to be protected. We shall also be following up on what is happening at the courts. Mr. Katto, asante sana. We continue with this conversation because it cannot just end here. We explore our future engagements on the same. My name is Dennis Aseto. To everybody that made this production a success, asante sana, and to the legends themselves, man. You just gotta love them. And finally, remember tomorrow to get yourself a copy of Kenya's bold newspaper, The Standard. Enjoy the rest of your viewing. Good night.